Welcome everyone. My name is Matthew Erie. I'm an associate professor at the University of Oxford and the principal investigator of the China Law and Development Project, which is a 5-year interdisciplinary research project funded by the European Research Council, which studies how China and the Asian region more broadly are shaping international law and regulation. And as part of the CLD project, we're very interested in building platforms for discussion, building bridges, if you will, to discuss these issues in depth. This is our first webinar, so welcome. I want to mention our co-organizers and co-sponsors. We're very fortunate to work with the following entities: the Faisalabad Industrial Estate Development and Management Company, the Ease of Doing Business in Pakistan, the Pakistan-China Joint Chamber of Commerce and Industry, and we're fortunate to have the president of that association in the virtual room with us, and the Center for International and Commercial Arbitration. Thank you so much to all of our co-organizers. So the goal of today's session is really to assess the cutting edge knowledge on commercial courts. As we all know, in recent years, a number of jurisdictions from the Gulf states to East Asia have established commercial courts. They are perceived by some to be the new DNA for promoting economic development and global commerce. These commercial courts take a number of different forms. Some are specifically domestic courts in nature. Others are geared more towards international or cross-border disputes. What binds them is a common aspiration to provide affordable, expeditious, and enforceable judgments, oftentimes, but not always, through procedural rules that differ from those of the broader jurisdiction within which they're embedded. I should mention that this webinar, the topic, builds on past research conducted by the China Law and Development Project, and we will include some of those links to the publications in the chat box for your reference. The immediate topic that brings us together is the establishment of the commercial courts in Pakistan through the Ease of Doing Business reforms agenda. We will hear from a number of insiders in terms of these new district level courts and the work that they are doing. We will then hear from an array of international experts who have firsthand experience in establishing and administering commercial courts around the world. Through these reflections, we will gain a wider understanding of the commonalities and differences between and among the commercial courts. We are particularly interested to know what are the most salient lessons to be learned in the establishment of the commercial courts, and in particular, as to such topics as the jurisdiction, legislative basis, the regulatory framework, relationship to domestic courts, staffing and personnel issues, the court's arbitration nexus, and enforcement concerns, of course. A few instructions for our audience members before we get started. Please keep your audio and your video off throughout the duration of the webinar. Each speaker is going to have approximately 12 minutes to give their comments, and then we will open up the webinar to questions and answers. How this works is basically you can write in questions through the chat box at any time, and I will moderate those questions. I will collect them and moderate them during the Q&A. And feel free to designate who you would like to address the question, or if you want to address it, if you want the panel at large to address it, then please make that distinction. Please ensure that the questions are respectful. Let's maintain a courteous discourse. Also, I should note that this session will be recorded. Moving on to our speaker introduction. So we aim very much for diversity of views. We will hear from experts representing a number of different jurisdictions and also professional viewpoints. So we have judges, we have a registrar, we have a lawyer who has argued before these courts. Informing our panel, we invited a number of female judges to join as speakers, but after a considerable effort, we were not able to secure their participation. And we believe that this state of affairs is symptomatic of a wider issue in terms of the lack of gender parity in commercial courts, and potentially that would be a topic of a subsequent webinar in and of itself. Moving on to our speakers today. We're very fortunate to have some excellent speakers. To begin with, Honorable Justice Mushir Alam. He is the senior puisne judge of the Pakistan Supreme Court, the chairman of the National Judicial Automation Commission, and he heads up the setting up of the Artificial Intelligence Cell of the Supreme Court of Pakistan. Next, we have the Honorable Justice Jawad Hassan, who is from the Lahore High Court. He is the brainchild behind the Commercial Courts Initiative. He is setting up the state-of-the-art commercial courts and he's also in charge of training the specialist commercial judges. Thirdly, we are very fortunate to have Barrister Nudra B. Majid, who is a civil, commercial, and criminal litigation lawyer. She is the lead draftsperson of the Chief Justice Committee for drafting commercial courts, primary and secondary legislation. Moving on, we're very fortunate to have Mr. Christopher Campbell Holt. He is the registrar and chief executive of the Astana International Financial Center, or AIFC, court in Nur Sultan in Kazakhstan. Next, we have Dr. Michael Huang, who is the former Chief Justice of the Dubai International Financial Center, DIFC courts. He is the former Judicial Commissioner of the Supreme Court of Singapore. He is one of the first 12 senior counsel of the Supreme Court of Singapore, currently practicing as an international arbitrator with a select practice as a senior counsel. Next, we have Sun Xiangzhuang, who is the judge of the People's Republic of China Supreme Court and judge of the China International Commercial Court, the CICC. And last but not least, very fortunate to have Yang En-Tian, who is a deputy chief judge of the Suzhou International Commercial Tribunal, also based in China. So without further ado, I now open the floor to Justice Mushir Alam. Justice Alam, the floor is yours. Thank you.
Thank you very much. Good evening, all the distinguished speakers and audience. I'm honored to be invited by the China Law Development University of China Center to join from Supreme Court of Pakistan at Karachi, this virtual webinar being held today on commercial court in a global context. I'm sure the webinar will be rewarding and enriching experience for each one of us. I hope when situation improves, surely we'll get a chance to meet each other. I'm sure today's webinar will generate dialogue and galvanize regional and global consensus on revamping calibration of a judicial apparatus to meet upfront challenge triggered by the Belt and Road Initiative. There can be no justice without socio-economic equality. Socio-economic equality will be an illusion without peace in the scheme of the thing. Justice is at the center of the stage. New World Order has been successfully replaced by the Chinese leadership that has evolved in 18th National Congress of the Communist Party of the China held in November 2012. It was declared that the mankind has only one earth to live on and countries have only one world to share. China envisioned a world order with shared vision of prosperity, good social order, peace, justice, marching towards common goal and shared destiny. Since February 2020, world is in the grip of a pandemic, COVID-19. World is not the same. Pandemic has changed the global socio-economic norms. Movement of citizens of all the countries has not only been restricted within the territorial boundaries, but between the state intersea as well. Economies of all the countries are facing recession. Industries as well as entire aviation industry have collapsed in this drastic situation. World is in the grip of challenge, and it is set challenge to create opportunity. We have gathered here to seize of this opportunity for building a judicial community with shared future under the new situation. Belt and Road Initiative, a brainchild of China, aims to realign, reshape the world. It is wholesome, all-inclusive initiative to take along all the nation states hand in hand in its journey towards good socio-economic opportunity, peace and justice. BRI is equal opportunity initiative of the visionary Chinese leadership. Journey of China to rule of law is inspiring. Major structural overhaul both in the Chinese constitution, legislative administration and structural reform in legal system through 4-5 years reform program by Supreme People's Court in 1999, 2005, 2009, 2014, and 2018, wherein 63 out of 65 reform measures were accomplished. which by any standard is remarkable achievement. Reform in judicial sector, introducing strict merit, entry of judges in judicial hierarchy, lawyers and legal profession on merit through tough examination process. Supreme People's Court has drastically enhanced judicial capacity of judges of all rank and file. Enforcement of High Code of Conduct, strict accountability of judges, lawyers has brought transparency in judicial process, which has earned both credibility and public trust. Use of the state-of-the-art next generation technology, including artificial intelligence, is indeed miraculous, making judiciary more competitive, responsive, and super efficient. All what I have briefly stated is indeed understatement. I, as a delegate from Pakistan in Shanghai Cooperation Organization Judges Conference held in April 2019, was bewildered to personally experience Shanghai High People's Court, Shanghai Financial Court, Internet Smart Court, Internet Court, Hangzhou, Xinjiang High People Court, Intellectual Property Right Court. I was amazed to experience WeChat mini court portal accessible through smartphone technology. Technology has virtually transformed the entire judicial system of China. I have personally witnessed sustained and phenomenal transition of Chinese conventional court to smart, intelligent courts. Achievement is indeed enviable, inspiring. Such transition is a giant leap forward. When I returned to Pakistan, drawing inspiration from China, digitalization of the court, undertook digitalization of the court in Pakistan. Pakistan is home to 220 million people. Judicial system is overburdened. National Judicial Policy Making Committee, comprised of Honorable Chief Justice of Pakistan and all the Chief Justices of High Court, have established National Judicial Automation Committee, of which I am presently the chairman. NJAC is tasked to formulate National Automation Action Plan to modernize the judiciary of Pakistan. NJAC in turn has formed a specialized unit called National Judicial Automation Unit, comprised of technical experts. Basic premise to establish it was to standardize the tool and practice across Pakistan. This unit, once operational, will become the brain of Pakistan judiciary and be instrumental in providing expeditious justice to the common citizen of Pakistan. NJAC is collaborating with National Center of Artificial Intelligence at National University of Science and Technology and National Information Technology Board, and it is in the process of establishing Artificial Intelligence Cell for the National Judicial Automation Unit for efficient and smart judiciary.
I'm sorry, Justice Alam, for reasons of time, could you please give us one last sentence, sir?
I would now only give a roadmap for establishing the global BRI court. In the first place, I would only request that a memorandum of understanding between the Supreme Court, all the superior courts in the BRI country to be engaged, and the matter relating to BRI, relating dispute, may come under the local court controversies. Special 6 regional BRI commercial court be established and special benches be established to hear the cases arising out of a BRI country dispute. Accredited legal practitioners from disputant countries may be established. I believe there are 6 region of BRI countries, 6 regional courts may be established, and 1 court at the Shanghai, China may be established as an appellate or review court to decide the dispute between the BRI countries. That is the summary of my entire discourse, which I wanted to share with the audience.
Thank you. Thank you, Justice Alam. Thank you so much. Very much appreciate your comments. Now we have Justice Jawad Hassan. Justice Hassan, please.
Good afternoon. This is Mushir Alam. I welcome the co-sponsors, the Oxford University, the Center for China Law and Development, the Pak China Joint Chamber, and Faisalabad Industrial Estate. Reason for setting up the commercial courts in Pakistan, I can sum up and that to show and demonstrate that we walk the talk, because after I spoke, as you taught the course at LUMS, Skandar Shah is also online here. The China Business Center at the LUMS Center for China Studies, and also we spoke at some forums on CPAC last year by European electoral. We felt the need that by examining the Chinese on CPEC issue, Mr. Mushir Alam was quite right to set up some kind of a forum, but on the private business by examining, being a lawyer for Pakistan and China before my elevation, as that Chinese don't prefer the arbitrations which are investing in Pakistan, and we wanted to look at the dispute mechanism in the contracts. There we have to give the confidence to the investor with the local courts. By examining the legal anthropology of the International Criminal Courts tribunal set up for the New York Convention on ICSID, and also analyzing the judgments passed by the domestic courts in implementing those awards, we have learned a lesson. And also by looking at the legal pathology of commercial dispute, commercial courts, we thought that we should focus something like on a state expense commercial court for the province of Punjab, which was then triggered off with the support of the World Bank. Ali Jalal is also participating in this. They came to us because they had to improve Pakistan's ranking for ease of doing business by the World Bank group. We thought to set up a commercial court at the district level. That was the requirement. And that requirement has been with us for almost a year now. Basically, Article 37D of the Constitution of Pakistan clearly states the state shall provide inexpensive and expeditious justice, which will then, because in arbitration, you have to first go to an arbitration, then second round of enforcing the award. In commercial courts, I'll walk you through the ordinance. What I'm speaking here today is lesson learned for what we set up for the overseas Pakistani cell. Punjab, I represent the Lahore High Court, which is the High Court of the province of Punjab, which is one half of Pakistan with 120 million population, with 36 districts, which are called states, which is the fourth most populous sub-national entity, and it has the largest earning of Pakistanis living abroad with 68,000 industrial units. So the reason being is we have a successful commercial court model. Details are given in the Lahore High Court website, opc.lhc.gov.pk, and all the lectures. When we established the commercial courts, we trained the lawyers and the judges through the help of the best lawyers, and all came and spoke to them at the Punjab Judicial Academy. And as you can see from the electronic media and YouTube, all 48 lectures of the top best commercial lawyers to the judges are recorded, and all are available on YouTube. Second is on the overseas, Pakistan received $20.22 billion from overseas, and we have also set up an overseas court to strengthen the confidence of the overseas in Punjab. And now it has been 2 years. The jurisprudence, the legal anthropology of the jurisprudence on the last 2 years, which is all available on the Lahore High Court website, clearly gives a positive indication that much cases have been decided. In the commercial court, the ordinance preamble clearly states that they will deal the issues with commercial transactions, and commercial disputes are all defined, which has the time frame of deciding a case within the 90 days and the appeal in 120 days. Being the High Court judge, I am the admin judge also, and under Article 202 of the Constitution of Pakistan, we have a supervisory capacity to monitor courts and which we have done so. In my Pizza Hut judgment, I delivered a judgment on the Pizza Hut case, which was on the issue of a commercial dispute of an international chain, where we have given out the issue of how the contracts are enforced, how the dispute mechanisms have been dealt with, and then the time frame given by the High Court under the Constitution is mandatory for a civil judge to follow. These commercial court judges are civil judges, but we have taken out them in separate way to set up specialized 24 hours a day. Those are the judges who have to do exclusively the commercial court matters, which are now bombarded with cases. They are dealing with cases in Multan, Faisalabad, Lahore, Gujranwala, and Rawalpindi. And a High Court website gives the time of the case filed, gives the time of the next date, and time frame of 90 days is given. Every judgment has the date of hearing and then date of decision. I am monitoring every week. I am giving directions through a registrar, through a DG, because this is a very good model. The model was only to say that it's a state's duty to give inexpensive and expeditious justice rather than going through the forum of other arbitrations, which I do agree, based on my experience as a lawyer defending cases in London and Singapore and Dubai, DFIC models. You have a very good model, but the main thing is the rule of law. That's what the philosophy of the entire commercial court is. The rule of law has three parts: access to justice. The courts are established under the Commercial Court Ordinance 2021. Number two, dispensation of justice. The justice is dispensed. I'm giving this statement to you. The High Court sites give you the number of cases decided. The World Bank, Ali Jalal and his team, Mishka Khan and all, they are every day pointing out in the web pages how many decisions have been taken and how much time was taken, because everybody is now monitoring us. Because our commercial courts are example to the world, from a Pakistan, a province with the support of the Chief Justice of Pakistan, and Chief Justice of Pakistan came to inaugurate the commercial court 2 months ago, and they came to train the judges in September 2020. And also, Mr. Mushir Alam is also a part of reforming the IT system, because commercial courts are all sitting here, because under Section 11 of the Commercial Court Ordinance, anybody can file a commercial court through an e-filing mechanism. This is a process which Mr. Mushir Alam invented the reforms in the IT. And last but not least, I want to clarify two things, that now, because these commercial courts were established with the purpose of giving confidence to the investors in Pakistan, and as you know, Chinese are the biggest investor right now in Pakistan. The $62 billion investment in Pakistan in private sector and in CPEC sector. I have a president of Pakistan Joint Chamber who can also give an answer and speak about that too. And that is, their issues are mostly dealing with the language issue, language barrier. They don't go for contracts. They don't go for arbitration matters. They go straight to, and once we told them and they were confident and they were nodded, that Pakistani courts in Punjab, where they have investing heavily through the exclusive economic zones, these business parks, they now know that now the commercial lawyers, the solicitors, the law firms drafting the agreements for them can write only that the dispute will be handled by the commercial courts under the Commercial Court Ordinance 2021 by a commercial judge within the time frame as prescribed by the law and monitored by the High Court. That's a very good model. And we have started this, and every judgments are now uploaded. We have given some judgments. I have a case which is pending. I can't talk more about it.
Justice Jawad, last sentence, please, sir.
Okay. Where a local court tried to intervene in the matter which was in the DFIC in Dubai. And those are issues where you have to think of how the lesson learned from Indian judgment of Bakshi versus McDonald. Those cases were how international tribunals and international arbitrations can be restrained or stopped by a local court. So those are the issues, and we have just set up with the blessings of the Supreme Court in line of the ICC, Astana. I can see people sitting here, AFIC, Singapore model, and we have learned a lot from you in our procedures, and you'll see us, we walking, not talking. Thank you.
Perfect. Thank you so much, Justice Jawad. That was terrific. Now we're going to turn to Barrister Majid.
Assalamu alaikum. and a very good afternoon to everyone from the monsoons of Lahore. I know Vicky, our Uber IT expert, has muted the audience, but while I'm speaking, if you hear participation of some audience in my background, those will be the thousands of migratory birds that are traveling through the Indus Flyway from Siberia to our Indus Delta. So I will try to keep them disciplined as per Michael's etiquette guidelines. Following on from the Honorable Justices, I just am going to share some additional micro background and genesis of our commercial court model. Secondly, as a lawyer and a user of the commercial court, I'm going to talk about what are our expectations from the system and from the judges. So turning to my first point on the background and genesis of the commercial court model, we've often been asked whether we are following the English model or the DIFC or AIFC court model. The commercial court model in Pakistan has been informed by both, but it is unique, not by virtue of any genius on our part, but as a result of circumstances. While commercial courts go back to 1800s, commercial courts in the last 5 or 10 years have mushroomed as a result of the cracks in international commercial arbitration. And international arbitration in itself became popular because of the deeper fissures in the civil litigation system. We see in commercial disputes, especially in international commercial disputes, that the higher the stakes, the more adversarial and extreme the approach has become in arbitration. So lawyers like me will scrape the barrel for every possible argument to put before an arbitration tribunal without fear of being disciplined, and in the hopes that if we lose, we have the possibility of a due process challenge. This has threatened the efficacy of international commercial arbitration as a speedy and cost-effective method of dispute resolution. In addition, aided to this is the fact that the use and development of IT and the reluctance of international arbitration tribunals to control the process for fear of due process challenges has become a double-edged sword. And that double-edged sword facilitates the production of massive quantities of documentation and data, increasing costs and delays to the point of being unmanageable. Reading, digesting, cross-examining witnesses on 50,000 pages is not a task that requires 2 months preparation. It is a task that requires 2 years of isolated dedication. It is quite simply not humanly possible for arbitration tribunals to control this and to decide fairly. At this point, may I say that when I read the late Johnny Weider's article on how the commercial courts in England were set up, it's an article titled Justice Long Lawrence, the True Begetter of the English Commercial Court, i.e., a judge who was so incompetent in commercial disputes that lawyers and commercial users in England revolted, which gave birth to the London Commercial Court. When I read that, I wished that England had banished Long Lawrence to the subcontinent in 1895, like it did so many of its other flaws. We would have turned him and the commercial courts around as we did the cricket, and London today may have recognized the subcontinent's contribution in its commercial court innovations as it does with Earl Grey tea and khichdi. Sadly, this was not to be the case, but for us in Pakistan, for our commercial court model, we have had the advantage of the wheel already being invented and designed in many different ways. We studied all the different designs and continue to do so in preparation of our final law and the structure of commercial courts. Before I mention some of the features of these commercial courts, I'd like to share that many of the innovative practices are already present in our civil procedure framework. As Mark Twain said, the ancients stole all our great ideas from us. But perhaps those innovations were made at a time when there was not such a need or market for them as there is now. And so we feel that we have done something fantastically novel. The reality is we are updating the spokes of a well-designed wheel. So our new commercial courts and the statute that will underpin it will reflect global best practices. For example, active case management led by judges, limiting lengths of submission, chess clock time management, strict adherence to procedural orders. We have also looked at CFOC, the Standing International Forum for Commercial Courts, and we have been informed by the developments of CFOC. In addition, restricting adjournments, which is the bane or perhaps boon, depends on how you look at it, of lawyers who have lost sight of the nobility of the profession. Most importantly, we have focused, as Justice Jawad has mentioned, on the commercial specialization of judges. In addition, we also have looked at models of court-mandated ADR, like in Switzerland, New Zealand, Singapore, our neighbors in India, etc. Alongside this, we are reforming our current arbitration and ADR mechanisms. The process has already begun in some of the provinces in the revamp of procedural laws. So in a sense, our arbitration reform is being informed by our commercial court structure rather than the other way around in different countries. And the commercial court structure, in turn, will aim to provide the necessary foundation for efficacy to the arbitration process in terms of enforcing agreements to arbitrate, interim orders, and enforcing arbitral awards. Turning to my second point, what, as lawyers, do we expect from the system and from judges? Well, as lawyers, we want a court that is actually experienced in commercial matters. We want a court to build up a commercial specialization so that lawyers are not educating the judges. This is key. Commercial court judges are not generalists. They cannot be. They have to build up their own knowledge of commercial law. As lawyers, we expect a tightness in procedure, timetables, stopping adjournments, active case management led by judges. A longer term aspiration, of course, is the building up of body of precedents. And since precedent is built on the appellate level, we are looking very carefully at our appellate structure in our current commercial courts model. These will be commercial benches of the High Court, which will have both original ordinary jurisdiction as well as, of course, appellate jurisdiction. We have a very growing body of very savvy Pakistani lawyers, both local and lawyers who are working abroad, who are plugged in 100% to developments here, and we are working with all of them. And it is from this body of lawyers that the motivation and direction is being fed to the judges of the expectation to have precedents written by judges that are stable, reliable, and most importantly for commercial courts, predictable, so that we want foreigners to come and opt for Pakistan law, just as England, but they had 400 years of commercial jurisprudence being built up, but just as Singapore is also doing. So it is with the same vision that we are progressing, but keeping in mind our own culture-specific and legal tradition-specific needs. Another important thing that we as lawyers expect of the system is that the commercial court system should bear resemblance to real-life commerce in its understanding. Often things happen in the commercial world which get misunderstood if a court does not understand them. We all know that the court is a parallel universe, whereas commercial dealings are another universe. Try explaining to a judge hedges, derivatives, commodities trading like circular trading. We really need specialist judges for that who have commercial knowledge and a commercial buildup of knowledge. Here in Pakistan, we have been informed by one of our own areas, a home ground knowledge in the form of the city of Sialkot, which is one of our big growth areas. Sialkot is the city where many of our export products are manufactured. Their dispute resolution systems are so effective and so historic that Ivy League universities in America, like Stanford, actually study them. Sialkot runs voluntary networks of trade organizers who subcontract on huge scales, but they have almost zero commercial cases in their courts because the rules of business are, they say, Either we solve this as an association or you keep your peace. But if you go to court, you are ostracized from being part of the riches that we all trade in. The system has worked, and it's these kinds of homegrown systems that we are also tailor-making that will suit our specific needs. So to conclude, we are mindful that while we set up a theoretically tight framework for commercial courts, the proof, of course, is in the pudding. And it will take time to build up commercial law jurisprudence. But already since the establishment of commercial courts, there has been an enthusiastic response from lawyers who have commented, criticized, and encouraged, and given very constructive direction. So we understand that it will take time, but we are on the right track in working with chambers of commerce and automating and working on IT. And all of that is feeding into what we hope very positively will be a great commercial court. So to end with, since this is coming from Pakistan, I will end with a verse of our poet-philosopher, Dr. Muhammad Iqbal, who said, "Nahi hai na umeed Iqbal, apni kisht-e-veera se, zara nam ho to ye mitti, badi zarkhez hai saki." Don't be dejected, Iqbal, at the barrenness of your land. A little water, and you will see, O water bearer, how fertile your land is. Thank you very much.
Thank you, Barrister Majid, for your insightful and erudite comments. Thank you very much. Now we're going to turn to Kazakhstan and Mr. Christopher Campbell-Holt from the AIFC Court. Mr. Campbell-Holt, over to you, sir.
Thank you very much, Matthew. It's my great honor and privilege to have been invited on behalf of our court, Common Law Court and International Arbitration Center based in Nur-Sultan, the capital city of Kazakhstan, to offer our perspective. May I start by warmly congratulating and thanking the previous speakers on their insight into what is happening in Pakistan at the moment. I find this personally, if I may say so, absolutely fascinating. Like some of us, or in fact all of us around this the screen on today's important webinar, I think we've all advised or been a part of the development of, in some ways, similar dispute resolution institutions all around the world. I mean, I've been fortunate to do this in the Middle East, in Qatar, throughout my region now in Central Asia, Sri Lanka, India, even Latin America. And we're not short of case studies, if you like, of these types of dispute resolution attempts to be put into place. One point I'd like to echo, if I may, is the idea about where we're coming from with these types of centres. What is our overriding objective? It differs in the specifics from jurisdiction to jurisdiction. Different governments, different countries have different reasons for wanting to create such centres or courts. Typically, in my experience, there seems to be a united position that by doing these types of operations and successfully and quickly in a way that is cost effective, will, we hope, significantly increase the overall attractiveness of a country for inward investment. It would also, we hope, increase the international reputation of the country and its system, and hopefully do everything that is possible to do from a dispute resolution perspective to make doing business as easy and hassle-free and cost-effective as possible. The AIFC Court and Arbitration Centre, very briefly, because I want to highlight some key pointers, I think, for everyone to consider, rather than just talking about our own institution, but so everyone knows who we are. The AIFC Court and Arbitration Centre are two separate independent legal entities. They are based within the Astana International Financial Centre, which was created at the instruction of the first president of Kazakhstan, the Elbacy, His Excellency Nursultan Nazarbayev. He wanted to bring an international approach to his country that would be immediately recognizable, reliable, and would gain instant confidence or quickly obtained confidence, earned confidence with the international and regional investors coming to Kazakhstan. The court is chaired by Lord Mance, the former president of the United Kingdom Supreme Court. Formerly it was Lord Wolf. Lord Wolf, myself, and Justice Huang, I believe, who's on this panel today, and others from Dubai worked very hard to create this court and arbitration centre. The judges have come from the English legal system, but they all have international litigation, judging, arbitration, and in most cases, mediation experience as well. The Arbitration Centre is chaired by Barbara Doman QC, more than 40 years litigation, arbitration, mediation experience based from Blackstone Chambers in London. And she was one of our judges in Qatar at our financial centre court in Qatar some years ago as well. The court and arbitration centre so far have already successfully resolved 567 cases, which for our type of international financial centre court and arbitration centre, we believe is exceptional. We did not expect this level of traction and actual tests and being used in practice at this stage. We're still only in the 4th year of our operations for the court and arbitration centre. All of those cases have been successfully enforced to 100% satisfaction. Key issues I'd like to bring up, if I may, and I hope this is of interest to the speakers and the participants today. When you're setting up this type of court or arbitration centre, indeed any dispute resolution institution, you've got to start with first principles. You've got to get the constitutionality right in your jurisdiction. In Qatar, we set up an international standard common law court for international investors into a new financial centre. We didn't quite get the constitutionality right, and this was picked up into our 5th year of operation, where over reading a newspaper over breakfast one morning, we'd found that someone had set up a constitutional committee to review our legality and our constitutionality as a court. We had to deal with this very quickly. It was a huge oversight, but I'm taking us back to 2004, 2005, when the creation of such international financial centre courts and dispute resolution centres was still very at an early stage. We did that, of course, with the support of many people in Kazakhstan, and we were very fortunate that the written constitution of the country was able to be changed very swiftly to enable us to have the tools at the highest level of the legal infrastructure that we knew we would need. The state relationship with an international financial centre court or a court within an existing infrastructure that's already there, such as what we've heard from Pakistan, is critically important. One of the key issues you're trying to encourage and assure investors is that what you are providing for justice is absolutely independent. There's no question of independence, impartiality, incorruptibility, and absolute strict international standard and compliance with the rule of law. Not just in some cases, in every case, specifically cases involving the local state apparatus. If you can't do that, well, you're wasting time and resources, because that is critically important. And you deliver that through the constitution, through the enabling legislation, if you need that, for a new financial centre court or arbitration centre, through the existing legal infrastructure that's already in place in your country, which will need to be amended sometimes to enable you to do what you know you need to do for the investors. And then you have to enforce it in practice on a day-to-day level, and you have to have a really robust system of judges who are internationally and locally trained, so they really understand the culture in which they're working within. They need to be profound experts in the areas that you know will be coming to the court or to the dispute resolution centre. You need to have a world-class case management administration, and it doesn't just need to work effectively, it needs to look and feel effective for your investors. The investors need to recognize it. They need to recognize the people leading it, at least to start with, so that they will trust the system. And then you need robust systems and people, frankly, in my experience, on the ground on a daily basis to ensure, when you're going through every single individual case management exercise, that everything is being done in the highest international standards. There are no fault lines. There's no possibility of corruption or inappropriate influence on the decisions of the court, even down to the initial receipt of the claim, all the way through to final disposition of the case. The appeal system, very quickly. I won't name the countries which I've looked at in this regard specifically, but I can tell you I find it surprisingly alarming that some countries want to set up a new international financial centre, but then they do not create a court that has a court of final appeal. They allow, or they, perhaps for political reasons, and they've not been able to achieve this when creating the centre from scratch, but to be able to have and to say to investors that your court is the court of final appeal is very important for investors if you're building a centre separate from adjusting the existing infrastructure, if you like. And who will the people be that will be responsible for enforcing that on a day-to-day basis? Enforcement. Far too often, in my experience, this is overlooked. You've got to show the investors and show them how they will be protected if they win a case, win a judgment. How is that going to be enforced? How quickly? We have enforced all of our cases. We haven't just relied on local court infrastructure. That wasn't good enough for us because we had a bad international perception of independence with our court system in Kazakhstan. We created from scratch a step-by-step procedure. We got all of the key state actors to sign it and to assist us with supporting our endeavors, but we have 100% individual responsibility ourselves for actually enforcing the cases, not just in our financial center, but throughout the entire territory of the Republic of Kazakhstan. Training has been mentioned. I won't spend any time on that, but that is critically important, not just a one-off. This needs to be on a continuing basis. And it needs to be, in my view, with interaction, not just from people within the existing jurisdiction in which you're operating and developing, but from the region, from the countries in which you're hoping to attract investment. You need to understand, the judges need to understand what is being expected of them, not just independence and impartiality and expertise in law and enforcement decisions, but the cultural understanding of the decisions they will be making in the context in which they are operating. I'll finish, if I may, because I think I'm running out of time, but engagement and promotions of what you're doing. This type of event is critically important. I would suggest significantly more can and should be done on a regular basis. There's no point having this system if no one really knows it's there or doesn't understand how it will assist them if they're an international or otherwise investor. You need a full media promotions campaign. We've done that. And as a result in Kazakhstan, we know as a very minimum number, we have been included as a dispute resolution center in more than 5,000 business contracts for disputes under those contracts. Most of those contracts have nothing to do with our financial center. It doesn't matter. We have opt-in jurisdiction. And I've not mentioned jurisdiction, but I'm sure others will do if I do not. But you've got to get the jurisdiction right and make it absolutely watertight clear so your users know precisely how they can use you to protect their interests. We all say the same things: swift, cost-effective, reliable justice. Let's not underestimate the power of IT and digitalization. That's very important. I wouldn't say exclusively, entirely for a dispute resolution institution. Judges will decide when they want to, when they feel it's appropriate in the interest of justice, to have a hearing face-to-face. And if that's so, then fine. But we have been, during COVID-19, resolving all of our disputes 100% online using digital technology and setting up a proper system of rules that can be applied in that, so it's clearly understood by everyone. The rules of the game, if you like, is so important. It can be done very, very successfully, quickly, cost effectively, but I wouldn't encourage anyone to be considering 100% digitalization for every case, because of course we take the approach in our court that it's really for the judges to decide on a case-by-case basis what in their decision is the best way, the most appropriate way to handle the case in practice. I think I've said enough for my time, and I'll hand back to you, Matthew. Thank you very much.
That's wonderful. Thank you so much, Mr. Campbell-Holt. Thank you very much for your frank and earnest assessment of setting up International Commercial Court, and really fascinating lessons that you've learned and provided us with. So thank you. Now we turn to Dr. Michael Huang, an individual who really has been instrumental in setting up a number of these centers and has tremendous multi-jurisdictional experience. Dr. Huang, over to you, sir.
Thank you. I'm going to do some brief comparisons between the DIFC courts, of which I was Chief Justice, and the Singapore International Commercial Court, which is quite a different animal. And you see two examples of different types of international commercial courts. Starting first with Dubai, why was it necessary to set up the DIFC courts? Basically, you had overseas investors and businesses who told the Dubai government, we like to do business with Dubai, we like to invest in Dubai, but we want to do business in English, and we want to do it in the way that we used to in the sophisticated financial centers that we are used to. And we also want to have laws based on English law, which we can understand, and it's more international. And we also need to have judges who understand English law, therefore are from common law countries. So the creation of a unique setup was what I used to call a common law island in a civil law ocean within Dubai, which is Arabic speaking and civil law. You establish a zone, the DIFC, which uses English to communicate in all business dealings. The regulations are based on models from New York, London, and the other well-known financial centers. And then you establish a set of courts applying English law, and in particular, the practices of the English Commercial Court, and of course, using the English language, and then having international judges from different parts of the British Commonwealth. And so that was the rationale of the original DIFC. There are several features about the DIFC, of course, stemming from those foundations. First of all, it was designed to hear only commercial and financial cases. We don't do any divorce, no crime. The choice of judges was not just to confine it to English judges, but to judges from the closest countries which did have English law as their foundation. So there were judges from not only England, but Singapore, New Zealand, Malaysia, and Australia. Now, the DIFC court was not originally conceived as an international court. It was international in the sense that any company which was incorporated in the DIFC, those companies which were DIFC incorporated, and they engaged in a contract with any other party, our law says that that transaction will be within the jurisdiction of the DIFC court. So any company that established in the DIFC court was able to do contracts in English and suck in, as it were, the counterparty into the jurisdiction of the DIFC courts. So we were mainly dealing with foreign companies who were established in DIFC, trading and contracting with other parties, whether in Dubai or other parts of the UAE or even elsewhere. In 2011, the scope of our jurisdiction changed when the ruler extended our jurisdiction to allow foreign parties to make the DIFC courts the court of a forum of choice. So they could have agreements to submit to the jurisdiction of the DIFC courts, and if this was submitted, signed by both parties to the contract, then we had jurisdiction. So that from that day on, we were a truly international court. I echo a lot of the things that Mr. Campbell has said about the other courts that he has worked in. We all have common aims in that sense. Being a small court, we rely very heavily on technology. We're probably the first court to a long time as the only court which is completely paperless. And this was dictated by choice because we were given the smallest public building in Dubai. And we had no space for paper. So from day one, all filings were by email and paperless and by electronic files. And that has continued through to the present day. Another very important feature about our development was that despite having a whole bunch of foreign judges to give confidence in foreign businesses who were entrusting their transactions to the DIFC courts, we needed from day one to establish, to train local judges to come on and become a part of our bench. And we identified 2 or 3 local judges of about the right age who could take off a couple of years, send them to England, get common law training, come back, serve as junior judges, and then eventually get promoted to full judges. And so by the time I had left, we had 3 quite experienced senior Emirati judges. And since I left 2 years ago, we've had 2 more. So we are well on the way to Emiratization of the senior judiciary. And for a long time, we've had a registrar who has grown from the day that we started the court to now to being the chief registrar. So that's roughly what the DIFC courts are about. Now compare that with the SICC, the Singapore International Commercial Court, which perhaps is a little bit more relevant to the example of Pakistan and other countries which want to establish a commercial court out of their local courts. So this is what happened in Singapore. We had a high court. We created a division of the high court and designated it an international commercial court with its own rules about jurisdiction, but it was and continues to remain part of the existing court structure. So there's no question of creating a new court from the ground up as we did in Dubai. Again, the remit of the SICC is for international and commercial cases only, no divorce, no crime. Jurisdiction comes either from a written submission or jurisdiction can be given to the SICC in the case of cases which have been filed in the ordinary division, the general division of the Singapore High Court, and then transferred over from the general division to the SICC. And that has been done so far by friendly persuasion. Cases are examined and the registry examines the characteristics of certain cases and tell the parties, we think that this case would be better tried in the SICC and explain why. And they've been quite successful in effecting regular transfers, which gave them a tremendous advantage in kickstarting the whole SICC as compared to creating a new court and waiting for the business to come in, waiting for people to sign agreements. Now, if you started a new international arbitration center, you would spend a year or so marketing it. You would spend another 2 years waiting for people to sign up and include arbitration clauses naming the new arbitration center. And then you wait another 2 years for the dispute to actually arise. So you probably 4 or 5 years down before you actually hear your first case. Whereas starting with an existing court and then transferring over the part of the existing caseload meant that more or less from day one, there were cases for the International Commercial Court to try. Again, the emphasis was on the international nature of this court. Now, in a sense, it went better than the DIFC courts, because when the SICC said international, they really meant international. And the judges came not only from the countries which were common law countries closest to Singapore, but also common law countries which were very far away from Singapore and were able to overcome the tyranny of distance in the sense that their judges were prepared to come over, spend long flights over to Singapore to hear cases and then go back. And it included countries like Canada and the US, but of course it's benefited from the breadth of their experience and the different outlook that they brought to commercial cases. The other very important feature about the SICC
sorry, Dr. Huang, I'm not sure if it's just me, but I can't hear you. Did something happen to your mic?
Sorry, somehow I must have muted myself. Where was I, Matthew, do you remember?
So you were discussing the setting up of the CICC and how the judges were coming from a long distance?
Yeah, okay. The other important feature is that we appointed quite a number of judges from civil law countries. And bearing in mind that Singapore is mostly in East Asia, and East Asia, apart from Singapore, Malaysia, Brunei, and if you stretch it down to the Pacific, Australia, and New Zealand, all of our other neighbors are civil law countries. So it was important to attract cases from those countries to come to our SICC. So we had a bench made up of eminent civil lawyers, not only from Asian region, but also from Europe. This court has a number of distinctive features which are different from any other common law court. we allow representation by foreign lawyers without having to apply on an ad hoc basis, on a case-by-case basis. If the case has certain foreign elements in it, then foreign lawyers can apply on a special basis to be represented without having to be admitted to the Singapore bar as such. We also have flexibility in procedures. For example, foreign law does not need to be actually proved by expert evidence and cross-examination. Foreign law can be proved by simply on submissions from, of course, lawyers qualified in those foreign laws. Singapore rules of evidence can be dispensed with if parties apply. So again, we are not tied to the Singapore common law system. If both parties are happier with civil law rules, then these international rules can be applied. For example, using the IBA rules of evidence, which are used in international arbitrations. Again, discovery, common law discovery can be waived if parties apply, and that can again be replaced by equivalent procedures in international arbitration. And unlike the General Division of the High Court, confidentiality can be applied for again with much more relaxed rules applying. And the range of cases available to the SICC is now steadily increasing. I think since last year, it has started to hear all the applications for setting aside of international arbitration awards. Since we have the benefit of so many distinguished foreign lawyers from not only common law countries, but civil law countries, it's great to have take advantage of that and to make use of their expertise to have a truly international reflection in our arbitration law. And finally, we are at the cusp of just starting to allow third-party funding for the cases in the SICC, which we do not allow for the General Division of the High Court or anywhere in the court system, although we do allow third-party funding for international arbitration. I think that should be sufficient for the time being to allow more time for questions. Thank you.
That's fantastic. Thank you very much, Dr. Huang, for really an expert insider comparison of the DIFC courts and the SICC. Thank you again for that. Now we're going to shift to China to understand developments there in the model that's been taken by Chinese experts. We'll begin with Judge Sun of the PRC Supreme Court and the CICC. Judge Sun, the floor is yours.
Okay, thanks, Matthew. Good morning, good afternoon, good evening, everyone. It's a great pleasure to be invited to this webinar. I'm going to say 3 points about practice and development of the China International Commercial Court, CICC. The first thing I want to talk about the background and process of establishment of CICC. The second, I want to talk about something innovative measures of the CICC. The third part, we are going to talk about the challenges we are facing now ahead. So the first part is the background and the process of establishing the CICC. The Belt and Road Initiative is one of the fundamental backgrounds to increase transnational commercial activities. With the increase of international commercial activities, effective settlement of international commercial disputes has become an inevitable requirement for optimize the ease of doing business and promoting global governance under the rule of law. So as of such, the Chinese government recently proposed that the rule of law is the best environment for ease of doing business. As a consequence, China needs to establish a dispute resolution mechanism matching both its economic size and its proposal. In order to improve their competitive in the field of international commercial dispute settlement, more and more countries have reformed their traditional litigation system and set up specialized judicial organs, the International Commercial Court. So does China. The first and the second International Commercial Courts of the SPC was established on June 29th, 2018 in Shenzhen and Xi'an, respectively. Since the first batch of cases were accepted at the end of 2018, and the first case were heard on May 29th and 2019, the establishment and actual operation of the CICC have attracted extensive attention at home and abroad. The establishment of the CICC is under the legal framework of China, focusing mainly on the high-value disputes arising from international trade and investment between commercial actors. So the stress rate for the first for the acceptance of cases should be the amount in dispute of at least 0.3 billion Chinese yuan. That is approximately 30 million euros. And we also have jurisdiction over discretion about over cases involving significant legal issues concerning international private law. So let me tell you some figures. The appointment of CICC judges, according to the judges law of the PICC, must be nationality, Chinese nationality. So currently there are 14 judges for the CICC. In the past 3 years, we have accepted 18 international commercial cases with parties from Japan, Italy, Thailand, British Virgin Islands, Anguilla, and others. 8 cases have been decided, and among them, 5 cases were related to arbitration. The first instance is final in our court. So the second part, I want to talk about some features of the CICC. A series of innovative measures of CICC have following the distinctive features, providing a Chinese approach for the construction of international commercial dispute settlement mechanism. First, the CICC pioneered the system of the International Commercial Expert Committee to improve its international level. So Chief Justice Huang is one of our distinguished expert members. Second, we created a one-stop platform aims at a more integrated dispute resolution system. So we have a one-stop platform, including our CICC, 5 leading Chinese international arbitration institutions, and 2 leading mediation institutions. Third, more flexible procedural rules cater for the international commercial cases. We also use digital technology to deal with CICC cases. The third, I want to talk about the challenges we are facing now. So with the past 3 years practicing, we find that it's an advantage and the advantage of pre-designed CICC rules. So we find there are at least 4 points we should be improved. First, the CICC needs to accept more leading cases and produce great judgments. Second, the International Commercial Expert Committee of the SPC should play more rules where no laws restriction. So we want to play a more important role in this field. Third, it is urgent to train and reserve international legal talents. So in China, I think we focus more about the experience of adjudication, and also I think English language proficiency matters for us. Fourth, continuous effort should be put on the international circulation of CICC judgments. We have a kind of a memorandum with SICC, and we also have some, strategy with Asean's countries. So as a major trading power in the world, China, especially driven by the BRI, have set up the CICC. So try to offer Chinese and foreign parties with a fair, efficient, convenient, and cost-conscious forum to solving international disputes. The CICC were based on the traditional advantage of the existing civil law tradition, learning from common law, Islamic law, other mixed law traditions, and adopting the best practice of litigation and arbitration to improve and promote international commercial formation and development of the basic principles and practices. The CICC will make a joint effort to provide a better service so as to facilitate the rule of law in the international business environment. Thank you for having me.
That's wonderful. Thank you very much, Judge Sun, for your very frank comments about the CICC, specifically in terms of its strengths and also its room for improvement. Thank you for your comments. So last but not least, we're fortunate to have Judge Yang from the Suzhou International Commercial Tribunal, where he is the Deputy Chief Judge. Judge Yang, over to you. Judge Yang, can you hear me? I think we may have unfortunately lost Judge Yang. It seems like his screen is frozen. While we are waiting for him to rejoin, and hopefully he will soon, I see that there are a number of questions already in the chat box. I encourage people to drop your questions in, and I will collect them. There are questions that range on a number of issues. Let me focus on one question that is kind of cross-jurisdictional. So many of the questions are specifically focused on, Judge Yang, is that you? Please, go ahead.
Sorry, yeah. So, okay, thank you very much, Professor Erie. Respected colleagues, it is a great honor for me to be invited to this webinar and share some experiences of Suzhou International Commercial Tribunal with colleagues from other jurisdictions. Since the Suzhou International Commercial Tribunal was newly established, my presentation today is entitled An Overview of Suzhou International Commercial Tribunal, hereinafter referred to as SICT. It will be given in 5 parts. First, I will brief you the establishment of SICT. Second, I will introduce the jurisdiction of SICT. Then we'll touch on the SICT Expert Committee, followed by a description of our neutral evaluation and mediation service. Finally, I will talk about the intelligent trial assistance system applied by our court. Part 1, the establishment of SICT. Suzhou International Commercial Tribunal is the first international commercial tribunal approved by the Supreme People's Court and established in a local court in China. It was inaugurated in November 2020. The tribunal has a separate office located at Suzhou Industrial Park in the Suzhou area of China, Jiangsu Pilot's Free Trade Zone, 15 kilometers from the headquarters of the Suzhou International Intermediate People's Court. For those of you who are not familiar with the Suzhou city, I would like to spend a couple of minutes to offer you a glimpse of it so that you can have a better understanding of its geographic and economic advantage. Suzhou is a modern city with a long history of more than 2,500 years, located about 110 kilometers west of Shanghai. Suzhou is a highland of China's opening up and development. At the end of 2019, Suzhou's actual use of foreign capital amounted to $132 billion US dollars, ranking 3rd among large and medium-sized cities across the country. Suzhou is also home to more than 300 regional headquarters and functional institutions of various foreign-funded enterprises, more than 400 projects invested by more than 150 Fortune 500 corporations and more than 20,000 permanent foreign residents. Suzhou has been selected as one of China's top 10 most attractive cities in the eyes of foreign talents for 9 consecutive years. In the past year, Suzhou achieved a total import and export volume of $322.35 billion, accounting for 7.7% of the country's total, behind only Shanghai, Shenzhen, and Beijing. In October 2015, the State Council approved Suzhou as the country's first area to carry out comprehensive opening up and innovation experiments. High-quality opening up and innovation require high-level foreign-related civil and commercial case trials as security. So SICT was born to shoulder the heavy responsibility. Suzhou Industrial Park, where the tribunal is located, is a demonstration base for China-Singapore cooperation at the third China-Singapore Law and Judicial Roundtable held in 2019. The Chief Justices of the Supreme Courts of the 2 countries proposed to strengthen cooperation in the field of international commercial dispute resolution. We will actively leverage the platforms such as the Joint Coordination Council established by China and Singapore for the Suzhou Industrial Park Development Project. The vice premiers of the 2 countries serve as the chairpersons of each party, and the China-Singapore Bilateral Working Committee to deepen cooperation and exchange between the.
Hi, sorry, Judge Yang, you're cutting out, sir. Judge Yang, can you hear us?
Yeah. Oh, yeah. Okay.
Please.
Okay. Let's continue. We will plan to promote the building and development of Suzhou Industrial Commercial Tribunal at a higher starting point, strive to provide inclusive, equal, convenient, efficient, intelligent, and accurate judicial services for Chinese and foreign parties, and build SICT into a new highland for resolving international commercial disputes. Part 2, I will introduce the jurisdiction of SICT. According to the approval of the Supreme People's Court and related regulations, SICT has jurisdiction over the following cases. Number 1, the trial of first instance of a civil and or commercial case with the subject matter of action involving a value of less than RMB 5 billion in the city of Suzhou. Number 2, cases in which the parties disagree with the judgments and rulings of foreign-related civil and commercial cases made by Suzhou Industrial Park People's Court and appeal. Number 3, other cases are accepted by Suzhou Intermediate People's Court that have foreign-related factors or are relevant with the opening up economy, including civil and commercial cases in which one party is a solely foreign invested enterprise, cases of letter of credit and letter of guarantee disputes, civil and commercial judicial assistance cases, and arbitration judicial review cases. In summary, SICT tries both first instance cases and appellate cases. SICT now has 6 judges and 10 clerks. Since its inauguration in November 2020, SICT has accepted 709 cases and concluded 438 cases, covering foreign parties from 29 countries. Part 3 of my presentation, Expert Committee of SICT. On March 30th, 2021, the SICT established its Expert Committee. The first batch of experts engaged by the committee, totaling 14, are all acclaimed experts and scholars with profound expertise in international trade, investment, and other legal fields. They will provide support in foreign law consulting, alternative dispute resolution mechanism, and academic exchanges. The expert committee is chaired by Professor Wang Guiguo, former Dean of City University of Hong Kong School of Law. Since its establishment, 3 experts have given their support in 3 cases respectively. In one shareholder dispute involving application of Ethiopian corporation law, an expert provided expert opinion on this foreign law. In another case, one expert shared her opinion on a controversial issue with regard to the application of CISG. Most recently, upon an agreement by both parties of a case, we invited an expert to mediate the case. After 2 rounds of online mediation conducted by the expert, the 2 parties finally reached a mediation agreement. Part 4, neutral evaluation and mediation service. On May 17th, 2021, SICT launched its neutral evaluation and mediation service. It is a court-annexed mediation consultation system. SICT appointed 16 neutral counsel and mediators from legal scholars and practitioners. This service is offered to parties coming to the court to select a neutral counsel and a mediator to provide them neutral evaluation of their case. Upon parties' agreement, selected mediators can conduct mediation independently. During the last 2 months, 7 cases had been concluded after successful mediation. The last part, intelligent trial assistance system. The intelligent trial assistance system designed by Suzhou Intermediate People's Court mainly covers 3 areas of support. The first area is electronic files. At the case registration stage, materials such as statement of complaints, responses, and evidence provided by parties will be scanned to electronic format and stored in the system. In the following proceeding, new materials such as trial records will be put into the electronic files simultaneously. Electronic files will be generated and circulated along the proceeding. The second area is online case handling. Electronic files will enable judges to handle the whole case process online without relying on the paper materials. The third area is intelligent facilitations. They include the following. Number 1, audio automatic transcribing. Trials, mediation, hearings can all be transcribed through language, automatically converted into words simultaneously and stored in the electronic files. The Suzhou Court took the lead in applying courtroom audio automatic transcribing program. Second, regulation searching. The SICT takes advantage of Faxin, a law database developed by the Supreme People's Court, which provides law resources support. Related laws and regulations can be automatically searched by voice in the courtroom, which makes the trial proceeding more efficient. Third, similar cases searching in cooperation with the Faxin database and by using China Judgment online case resources for cases handled by judges, the system automatically pushes related and similar cases according to course of action. Judges can also set the conditions for further search of cases to prevent similar cases treated differently. The intelligent trial assistance system greatly improved the quality and efficiency of case handling. I will wrap up here. Thank you for your kind attention. I'll be glad to take questions in the Q&A session. Thank you.
That is tremendous. Thank you very much, Judge Yang, for the extremely informative account of developments there in Suzhou. So now we're excited to turn to our Q&A session. I have my own question, but since we already have a number of questions listed, why don't we just launch into those, and that will hopefully facilitate more interaction between our audience and our experts that are assembled on our panel. So a couple of questions that are directed to the panel at large. So there's a couple questions here. One is the extent to which joinder and consolidation issues that are common in international arbitration can be addressed successfully by international commercial courts, right? So whether or not the commercial courts can address those common issues of joinder and consolidation that plague arbitration, and what does that look like? A second question that goes to everybody, but actually specifically to Pakistan, is when one of the commercial courts is established, how important is it to achieve a positive buy-in from the local legal profession who may not have experience with a commercial court, or in particular international commercial court. So how is that buy-in achieved, and how is this going in Pakistan? So why don't we actually address this sort of in order of our speakers? And I invite one of our representatives from Pakistan, maybe Barrister Majid, you can take that second question, and then Justice Alam and Justice Jawad could take the question on joinder and consolidation.
Sure, Matthew, thank you very much. So as I understand it, the question is, how do we get the lawyers to support and buy into the system? Well, that's a initiative that Justice Jawad had already begun last year in April 2020, when the former Chief Justice of the Lahore High Court, by notification, nominated commercial court judges. Justice Jawad immediately reached out to a number of local lawyers in order to work with them. So lawyers who already had commercial expertise were brought in to give lectures, and equally to just market the product, so to speak. So that's one of the things that began last year, and it continues now, and we're reaching further and wider. Having said that, we, I think, have the world's 5th largest per capita population in numbers of lawyers. So there are as many lawyers who will be a little hesitant because of not understanding the system as yet. So we have both on both sides, but the ones who are experienced in commercial law, as I mentioned before, are very savvy, and they're the ones who are going out writing a lot of articles in newspapers, giving talks and lectures. So it's a work in progress.
That's great. Thank you very much, Barrister Majid. Now,
I think, sorry, Matthew, I think Justice Jawad may want to just add on to that.
Sure. Justice Jawad, would you like to add on to that and also address that earlier question about the joinder and consolidation?
Yeah. Well, actually, while we're speaking, as you know, that Shafqat has just given the outline of the course, because as you know, I was reading the question and answers in the chat, because once we designed the commercial court judges training, I designed with sitting with lawyers and judges and with Professor Shahid Kareem. We made all kinds of issues related to commercial law and got the best lawyers coming and speaking to them at the Judicial Academy for a week. And then second time again, when the new court judges were appointed. So those are, as you know, all can go to YouTube and type commercial court Lahore or Pakistan. All good, excellent speakers you can see, and judges have learned from them. How I'm saying is now to check out what the experience is, the judgment smells it. The judges who were civil judges were no exposure to commercial court, because as you know, we were grown up in the commercial law practice. I started my practice in commercial law, traveling all over the world on commercial law. So that was something we all are inherited to. But people who don't have a commercial background, because banking, company law, special relief act contract, those are issues which are in force majeure post the COVID-19, what the English government has done to SIGA, Corporate Infrastructure Governance Act, the case of the very famous case of Virgin Atlantic. Issue is how courts came into a moratorium. We have even taught them too, that even in force majeure at the day to do at the time of COVID, because every dispute with the agreement has fallen back. The landlord issues, the factories issues, the suppliers issues in Pakistan. COVID has affected the economy also all over the world. But those judges stood there. They handled cases. I was monitoring them. And also I keep on looking at the areas to focus on. And then immediately we invite the judges again on Saturdays to be trained by lawyers, or by me, by even the Nudra is here. We'll ask Mr. Mushir Alam to have a visit to Lahore again to train them. So that's how we're doing it. And it's something indigenous. We've done it by learning from experiences. And I hope people will like it. And you know, whatever I've said, I can't say more because people have written on it now. If you Google commercial courts Punjab, all newspapers, law journals, even in a book, people are now writing about it, pros and cons. Even Nudra write about, criticize it also. And she wrote something about commercial courts.
Thank you very much, sir. Any thoughts about the joinder consolidation issue as addressed by commercial courts? I throw that out to anyone. If not, we can.
Well, from our perspective, commercial courts can solve the problem of joinder and consolidation because the court's jurisdiction is not limited to the parties to an arbitration agreement. So in principle, that is not a problem for the courts.
So two is that commercial courts have two things to do. A, the commercial dispute where there's no arbitration clause, they have a time frame to decide a suit or a plaint and electronically which filed. Secondly, to enforce the award made by the parties under the old Arbitration Act. But the New York Convention, which is in your interest to the international community, is I am and some other judges are nominated under Section 2 of the New York Convention 1958 because that is only the High Court, because High Court implements the foreign awards, but if it is a local award or award is labeled as local award, then those commercial courts, they have to enforce that award, because what interest to a foreign investor is whether my award taken abroad, how much time will it take to be effected and implemented? That answer is High Court, less time, commercial court, comma, now next time.
Terrific. Thank you very much, Justice Jawad, for that. So let me shift now and ask a question to Judge Yang. So we have a couple questions for you. The first is a little bit of an echo where that's coming from, but in any event, I'll continue. The first question is regards to the problems that Chinese investors face in a country like Pakistan. The question is, in your point of view, how can a legal system such as that of Pakistan be made more friendly or friendlier for Chinese investors in particular? And then a second question for Judge Yang, how do people's courts deal with the overlapping jurisdiction of more than one court? For example, if a case is accepted by more than one people's court. So what the questioner has asked is, given the broad formulation of hierarchical jurisdiction, GBA Guanxia, and multiple territorial jurisdiction, DU Guanxia, of courts in the Chinese civil procedure law, this is supposed to be a practical problem also regarding the Suzhou International Commercial Court, I would guess. So those two questions to you, Judge Yang.
That what's my comments on the investors in Pakistan? Is that right?
Yes. So from your perspective as a judge sitting in China, how could a legal system of a BRI state be improved to facilitate Chinese outbound investment into that jurisdiction?
Well, that's a very good question. I think, there's just the justice from Pakistan mentioned that China now is the largest foreign investor in Pakistan. Historically and currently, the two countries have very good relations. So there's a lot of economic and political interactions between the two countries, and so I think that for the Chinese investors, they have, because the stable relations between the two countries, the investors in China has confidence to invest in Pakistan. I think how to boost the confidence for the investors, I think, is that to strengthen the communications between the two legal systems, and especially in the judicial sectors, so that to make the Chinese investors to get more familiar with the Pakistan judicial system.
Thank you. That's very good. Thank you. And do you have a response in terms of the procedural issue, sir?
I mean, the jurisdictions, overlapping jurisdictions across China and overseas jurisdictions.
So I think the question was more in regards to, so let me read it again for you. So how do people's courts deal with overlapping jurisdiction of more than one court? For example, if a case is accepted by more than one people's court. So it's a domestic jurisdictional issue.
Oh, yeah, I understand. That's just within Chinese jurisdiction, within China, right?
That's correct.
Yeah, well, for that is according to our civil procedure law, there is several circumstances. For example, if they are both two or more courts have jurisdiction over a case, the first court that accepts the case will have the jurisdiction, and if that court found the acceptance of the case is wrong, the court can transfer that case to the other jurisdiction that this court thought that the other court has the jurisdiction. If the other court of the two courts has different opinions on the jurisdiction of the particular case, they will report to the higher courts of the both courts to a higher level. For example, two intermediate courts within Jiangsu province, if they have disputes or different opinions on a jurisdiction of a case, they will report it to the high courts of Jiangsu province. And then the higher level of the court will decide which court has the jurisdiction.
Thank you. Thank you very much, Judge Young. So now, if I may, I'd like to shift to Dr. Huang, a question for you, sir. So the question is, somebody's saying they don't see many SICC clauses in agreements. Could it be due to the current disparity between the enforceability of SICC judgments and arbitration awards, thereby restricting the circumstances in which parties will prefer the SICC to situations where enforcement will take place in Singapore itself or in a country where parties are relatively confident a Singapore judgment will be enforced? Any thoughts about that, Dr. Huang?
Well, first of all, the SICC has very full website, and all kinds of questions are answered on that website, including the ones that was just asked. The answers for enforcement of SICC judgments are actually the same answers as you might ask of any court. And basically, the world is divided into common law courts and non-common law courts. Common law courts will enforce anyone's judgment, whether they are civil law or common law, provided you satisfy a few basic rules. Civil law courts will also follow the same basic rules, but many civil law courts will add one more requirement, which is the common law courts, which is reciprocity. You recognize my judgment, I'll recognize your judgment. This reciprocity requirement is not part of common law doctrine. So SICC judgments are like any Singapore court judgment, is recognized throughout the common law world. And then with civil law countries, it's usually either by treaty or if they have signed up for the Hague Convention on Choice of Courts, or there are bilateral arrangements which may not be actual treaties, but Singapore has signed many memorandums of understandings with certain countries, including China, that each side will recognize each other's judgments. But in any event, Singapore's judgment to qualify for recognition in China by virtue of the doctrine of reciprocity, because Singapore has a record, a documented record of actually enforcing Chinese judgments in Singapore. Therefore, China has decided recently that they will recognize by virtue of reciprocity. So that particular doctrine does not interfere. The other question is whether or not there's a take-up for new cases going to the SICC. I explained to you that since they started in 2015, the main bulk of the cases coming into the SICC has been transfers from the General Division. I think the figure is up to the middle of this year, 63 cases have come over from the General Division. Now, I think it started in 2018, the first case of new filing. Now, I told you just now that if you establish a new international arbitration center, it might take you 5 years to have your first case heard in that arbitration center. because of marketing, because of time for people to write them into the agreements, for breaches to occur, and then for the arbitration to be filed. But because of the publicity given to the transfer cases that started from 2015, by 2018, there was the first case original filing, which meant that somebody had signed an agreement to choose the SICC. Since then, the case numbers per year are still in single digits, but they're improving year by year. So they've kicked off already since 2018. Up to now, I think they've had about 7 or so cases of new filings, as opposed to transfer cases. So I mean, for the new institution, that's doing pretty well.
Thank you very much, Dr. Huang, for that. Barrister Majid, you wanted to further address the issue of how BRI states, for example, Pakistan, could improve their legal system for attracting Chinese investment?
Yes, thank you, Matthew. I just wanted to share here that it's not actually how the legal mechanisms can help the foreign investor. It's many steps before that, and that is the initiatives that are being taken by chambers of commerce. And I think the president of the Pakistan-China Joint Chamber of Commerce is here. I know for a fact that when they set up the chambers at the start of the announcement of CPEC, the BRI project, way back in 2013, one of the first things they invested in was to train 25,000 Pakistani students in Mandarin Chinese. And they have been trained to level 4, which is the interpreter level. But the president of that chambers is here, and perhaps if you give the floor to him, he can tell you more about the things, because we've been working in tandem with these chambers also, and they said, forget the commercial courts are really distant in the future. We are talking about mechanisms and steps that we need to take much before we get to the stage of actual dispute resolution.
That's very, very interesting. Thank you, Barrister Majid. Mr. Naveed, did you want to voice in on that? I don't know if you're able to. Otherwise, we can circle back. Can you hear us?
Do you want to speak? Yes, Matthew, thank you very much. Can you hear me?
Yeah.
Can you have video of this? Yes, fair. Matthew, thank you very much. First of all, I would like to give a very brief introduction of Pak-China Joint Chamber of Commerce. The idea behind the establishment of this chamber was to create a specialized chamber to facilitate investment and trade relations with China. Pak-China Chamber, since inception, has strengthened bilateral business, investment, and cultural ties between the two brotherly nations. And we are playing a very important role, mainly in the accomplishment of CPEC and One Belt, One Road initiatives. Besides facilitating joint ventures, arranging delegations, and helping businessmen of China and Pakistan in the visa process, Chinese language courses, managing delegations, and the chamber has also managed cultural youth exchange programs, academic scholarships, and technical trainings as well. And we have what we have experienced is that, as Nuzhat rightly mentioned, what we are experiencing is that before the commercial courts, there is a long way to achieve for the Chinese investors. When they come to Pakistan, the first thing is to enforce or to make sure that they come into a contract between the Pakistani businessmen and Chinese businessmen. Because what is happening is that contract is not done and the company is formed and they start the business without any legal contract, which is a big problem, that when they go to commercial courts, there's no written contract. And this is something which I think Board of Investment can do much better than the registration office. So we are recommending to the government also to initiate board of investment, that any investor who's coming to Pakistan should go through board of investment, and they will regulate the contract matters.
That's very helpful. Thank you, Mr. Naveed. I appreciate your expertise and insight. Let me shift now to ask a question of Judge Sun. There's a question about the composition of the judges. I'm not exactly sure what that question is driving at, but maybe you could talk a little bit about the background and expertise of the judges that comprise the CICC bench. And then an additional question to you, sir, is to what extent can you represent that the commercial court judges are free from the influence of the Communist Party? Those are two questions for you.
Thank you, Matt. The first question, I think I have talked a little bit, then I add something. Currently, we have 14 judges for the CICC. They are current judges from the SPC with rich experience in trial, expertise in international treaties, international practices, international trade and investment practices. They can use Chinese and English as working language fluently. So the second question, I think I should say we follow the 3I to deal with cases we accepted. That is impartiality, independence, and integrity. I think my colleagues are very integrated for the cases and for their judge careers. Thank you.
Thank you very much, Judge Sun. So if I may, I'd like to ask my own question just to insert it. And this is a question that can be taken up by anybody, but let's start with Mr. Campbell-Holt. So there's a number of vehicles or platforms or networks that are kind of emergent now that are connecting some of these international commercial courts. We've talked briefly about the Standing International Forum of Commercial Courts. I know that you have experience in a number of jurisdictions, so that's also an important angle on this. And they promote sort of connectivity between the courts. What do you see as the major issues confronting commercial courts sort of writ large, and how can these platforms or networks assist in promoting these causes? And so one example, for instance, would be promotion of enforcement issues through the Hague Convention on the Choice of Court Agreements of 2005. I'm curious if the commercial courts are kind of mobilizing these platforms to further promote that particular convention. Any thoughts that you have, Mr. Campbell-Holt, and then we'll move on to the other experts.
Thank you, Matthew. Yes, absolutely. I think you cannot underestimate the power and the importance of international cooperation, indeed cooperation amongst all elements of a judicial and legal system. SIFOC, for example, the Standing International Forum of Commercial Courts, has been hugely important, and it's building speed in the last 3 or so years. And the key issues we tend to discuss are enforcement. Enforcement, from our perspective, certainly in the AFC court, is critically important. It's important to everyone, but if you engage internationally on enforcement court to court or through government entities where that's necessary, you need to have it as streamlined and as reliable and effective as possible. So international cooperation in that topic is very important. You'll find, though, that increasingly courts are cooperating at all levels of their business. It's procedural rules, enhancements, improvements, new innovative ideas, to training of judges and the lawyers within the community, down to promotional efforts, to IT. All of these topics we discussed earlier this year on our annual SIFOC conference, which I believe was hosted by Singapore. There's further scope for improving that. We at a court in Kazakhstan, at the AFC court, are focused on our immediate stakeholders. So you need to work out who are the people that you're trying to satisfy to use your facility, and then how do you do that in the best possible way? By partnering with other centres within the Central Asia region who do not yet have what we have created in Kazakhstan. That has been enormously important. It's also enabled us to take on more caseload by making people better aware, informed of using us. We've signed more than 30, I think it is, memoranda of understanding or such cooperation agreements all around the world. And it really is important. It serves many purposes, which are in the interests, I would say, direct interests of the users of your facility.
Wonderful, thank you, Mr. Campbell-Holt. Any additional thoughts from our experts on this question of international collaboration? Justice Jawad, please.
Yeah, it all depends on the country because if you are signatory to New York Convention, because most of these awards are all outcome of if states are party to New York Conventions, and then that is the award to be taken and enforced by a specific law. As recently I was helping out the Asian Development Bank when they were trying to have the South Pacific islands and all the countries to, I've written a chapter on them also 2 months ago. They are trying to convince those states, Fiji and all other states, to think about signing and ratifying the New York Convention in order to have the enforcement of their commercial disputes through a forum which could be IFC, DIFC, Singapore, because as you all know, because when we started practicing back in 80s, at that time, Paris was the favorite choice because of economic exchange rate. Then London became a very favorite spot because the English judgments were coming out in favor of the awards and all. Then when it became expensive, then they moved to New York. Then they jumped to Singapore. Now finally in Pakistan, before my elevation, I remember most of the clients, because of the exchange rate, and they don't, because these are very expensive lawyers and also the forum, they now prefer DIFC London Court of Arbitration, because that is very feasible to most of these people now. And still it's expensive, but Singapore also, I did 3 arbitration in Singapore. That is also very effective, even in a case of 2 Pakistani parties agreeing to a clause in Singapore for a foreign award, because that is only if a foreign award that is enforced through these international forums. Excellent work is done by even China in Hong Kong. CIATIC is Chinese model. CIATIC is the new model they're picking up. So those are all, as Chris Campbell-Holt was mentioning, is which states are party ratified the New York Convention. And once they have done so, then a confidence to the investor to invoke those clauses, to go for these centers in order to implement the award in the domestic countries. I'll give a floor to Naveed also.
Yes, I would like to just say that the commercial courts are working well in Pakistan, and I've seen practically that the confidence level of our Chinese brothers, our Chinese investors, the confidence level and trust level have increased tremendously, and the reason is because it takes less time and less cost, and with time limitations. So this is something which is remarkable, what courts in Punjab are doing. Thank you.
Thank you, Mr. Naveed, and thank you, Justice Jawad, earlier. So if there aren't further questions, Mr. Campbell-Holt, did you have a further thought on this? Yep, please.
Thank you. Very quickly, for what it's worth in the time we have. Back to the question on cooperation. We all speak to lots of different jurisdictions at various times, but it's all very well talking about enforcing international arbitration awards and signing up, ratifying the New York Convention. In my view, my experience, not enough work is being done on the specifics of actually enforcing arbitration awards in far too many countries around the world, even countries who have signed up to the New York Convention. For an investor to just assume that because a country has ratified or acceded to the New York Convention, that they will therefore get a fair enforcement at international New York Convention standards is simply not right. And you see it all the time, from the leading global energy companies all the way down to smaller operations, where there is a fundamental misunderstanding and they're hurt when they don't get what they believe they are entitled to in practice. There needs to be more cooperation, in my view, state to state, but with the actors within those states to ensure there are better on-the-ground procedures to ensure proper, effective enforcement.
Thank you very much, Mr. Campbell-Holt, for those further thoughts. I want to ask a question now back to Judge Young. This is an interesting question about automation, right? So everybody's talking about technology, the digitization of the judicial process and procedures. The question for you is, how much weight is given in conclusions on points of law produced by automated programs during court proceedings? Do you see the evolution of AI and automation programs moving from research tools to what are sometimes referred to as robo-judges, particularly in cases of small pecuniary value in the future? Further, the person says, in many common law countries, questions are raised as to the impact of such development and questions of potential violations of principles of natural justice and so on. Are there similar discussions in China? Judge Yang. Judge Yang, you're on mute, sir.
Sorry, yeah, okay, yeah, come back. So currently, for the automatic intelligence technologies used by our courts is basically in 3 areas. Mostly is for the case handling and intelligent facilitations and electronic files. So currently, at the current stage, the automatic intelligence system is helping judges to handle in cases, but not legally, to analyze the cases. But in the future, I'm not sure the trend, but I'm quite doubtful about that. I think the judges' jobs cannot be replaced by automatic or artificial intelligence. That's my thought on that point.
Thank you very much, Judge Young. Any additional thoughts from our other experts about this question of integrating technology into the courts, and where do we cross the line between technology that supports sort of research questions and analysis to the question of potentially technology taking the role that judges assume in terms of making legal arguments and broader judicial and even moral claims. Any further thoughts about this question of technology?
I may perhaps give you a little insight that we are engaged with the National University of Science and Technology Artificial Intelligence Department. They are working closely with the research department of the Supreme Court, developing a software to summarize the case proceedings. That will greatly assist the court in summarizing the case proceeding. And after summarization of the case proceeding, it may also give a predictive questions that need to be answered by the court. And then it is the duty of the judge to apply his mind and give a final judgment that may perhaps expedite the justice delivery system. And artificial intelligence also being used to streamline the flow of the cases, fixation of the cases, case management, identical case stacking together, so that bulk of the cases, if at all there are bulk of cases on the similar point, that artificial intelligence may identify such number of cases and club such cases together so that there may be minimum difference of opinion by the court. That is one of the area where we are working.
Thank you very much, Justice Alam. It's a fascinating area for further development and research. We have about 30 seconds left, so I just want to take this time to sincerely thank our experts for joining us, for sharing their knowledge, their experience, and expertise. For some reason, I'm being muted, but I will finish my sentence. It's been a very enriching event with all of you, so thank you very much. We look forward to further conversations with all of you, and thank you again for your time. And also thanks to the audience for joining us from around the world. Very much appreciate your comments and your questions. So thank you, everybody. All the best.